Your Honors, California has long been a pioneer in the field of anti-discrimination law. Its laws against disability discrimination predate those of the federal government by more than a decade.
That's at the gist of this whole case, isn't it, that California has been a pioneer, as you would call it. The federal government has not been.
Are we here dealing with physical disability?
Yes, Your Honor. Mr. Ross has a disability in terms of he has back spasms and severe back pain.
And I further presume that these particular injuries were sustained while he was serving in the Air Force. And as I recollect from the facts, and naturally you can correct me when I don't have them right, but based upon my recollection of the facts, after he got out of the service with these presumably severe injuries, he tried a number of medications or whatever was prescribed, and they didn't work out. And my recollection is that under the facts of this particular case, his doctor then prescribed marijuana to deal with the chronic back pain. Is that it?
Yes, Your Honor, in 1999.
Next question. Is it your view that under relevant California law, it is not a crime to be using marijuana when that is prescribed by a physician?
I believe that's well established, Your Honor.
When an employer hires someone, they I think, want some assurance that the employment will be continual employment, uninterrupted. And so how do you address the concern of employers that the person hired would be subject to federal arrest and prosecution for illegal drug use? That's my first question. Does the employer have a right to consider that issue? In other words, when faced with two equally qualified candidates for employment, one who does not violate federal law in terms of drug use and the other who does, is it inappropriate for the employer to make a choice based on the need for assured continual employment?
Yes, Your Honor, it would be inappropriate. That's precisely the sort of discrimination that's prevented by the Fair Employment and Housing Act.
So what happens, let's take it one step further. Let's say we accept your position, and then let's say the federal authorities do prosecute. Would it be inappropriate for the employer to terminate the employee based on that circumstance?
I believe it would be, Your Honor, but I would like to explain.
In other words, if the employee is charged and tried and convicted of illegal drug use under the federal law, and the employer took any steps adversely affecting the employee's employment, it's your position that the employer would be in violation of the Fair Employment and Housing Act. Is that right?
If the trial and prosecution did not affect the employee's ability to perform the essential functions of the job. As an initial matter, I would like to note the idea of a single patient being prosecuted by the federal government is wildly speculative, as Judge Kaczynski pointed out in the Conant case in footnote 10, where he explains essentially that the federal government does not go after individual patients. But taking this possible scenario into account, employers are faced under the Fair Employment and Housing Act consistently with some cost. There's some cost to an employer. The employer has to build a wheelchair ramp. That's going to cost the employer something. I mean, the FEHA does impose some burdens on employers. Here, the idea of the completely speculative possibility of a federal prosecution of an individual patient is not a cost that rises to an undue burden.